Hello everyone, welcome back again to my channel. Before watching this video, don't forget to like, comment, and subscribe. Now let's start this video. Indonesian salvage law within the framework of contemporary maritime law part 2. However, the tribunal, if it deems it fair and just to do so and bearing in mind the relevant criteria set out in Article 13, paragraph 1, may increase such special compensation further, but in no event shall the total increase be more than 100% of the expenses incurred by the seller. Third, self-expense for the purpose of paragraph 1 and 2 means the out-of-pocket expenses reasonably incurred by the seller in the salvage operation and a fair rate for equipment and personnel actually and reasonably used in the salvage operation, taking into consideration in criteria set out in Article 13, paragraph 1, H, I, and G. Fourth, the total special compensation under this article shall be paid only if and to the extent that such compensation is greater than any reward recoverable by the seller under Article 13. Fifth, if the seller has been negligent and has terribly failed to prevent or minimize damage to the environment, he may be deprived of the whole or part of any special compensation due under this article. 6. Nothing in this article shall affect any right of resources of the part of the owner of the vessel. The fair rate in Article 14, paragraph 3 referred to the daily commercial rate for hire. Article 14, especially those related to the remuneration award, further referred to SCOPIC clause, special compensation protection and indemnity clause. SCOPIC clause is formulated especially by the subcommittee of the salvage liaison group to overcome problems resulted from different interpretation of Article 14 Salvage Convention 1989 and to answer insurance problems related to the lack of information and involvement in a certain salvage case. However, there is misunderstanding related to the application of SCOPIC clause, which includes the expiry date and termination of SCOPIC clause. In relation to the earlier, while some business parties in shipping industry consider that Article 14 of Salvage Convention is still exists even if subclause 2 of the SCOPIC clause was used or even if the parties has cancelled SCOPIC clause based on subclause 9, the SCOPIC clause is still applicable in the fact whole SCOPIC clause will replace Article 14 of the Salvage Convention 1989. If the parties have agreed to use SCOPIC clause in determining salvage award, it is not possible to apply Article 14 of the Salvage Convention 1989. Further, misunderstanding was related to the provision of termination in subclause 9. Salvors can only cancel the salvage agreement or SCOPIC clause based on subclause 9. However, the ship owner can cancel the SCOPIC clause based on subclause 9. Another international instrument related to salvage was the Code of Practice between International Salvage Union and International Group of P&I Club. This code provides the application of Article 14 of Salvage Convention 1989. Meanwhile, for the salvors, limitation of liability was provided in the Convention on Limitation of Liability for Maritime Claims 1976. Article 1 of the Salvage Convention 1989 defines salvage operation means any act or activity undertaken to assist a vessel or any other property in danger in navigable waters or in any other property in danger in navigable waters or any other waters whatsoever. It follows from the above definition that there are at least four factors regarding salvage, which include an effort conducted by salvors, at sea requirement, conducted based on voluntary nature, and the salvage effort should be successfully or successful service. Furthermore, salvor can be defined as one who, without any particular relation to the ship in distress, proffers useful service and give it as a volunteer adventurer without any pre-existing covenant that connected to him with the duty of employing himself for the preservation of that ship. At sea requirement means that such accident should happen in navigational tidal water or in docks enclosed from tidal waters by gates, since the tidal waters are adjacent to waters forming part of the complex of a basically tidal part of harbor. While the obligation of successful service referred to the principle of no cure no pay, good pay and those reward will be given based on salvor's contribution during the salvage effort. In theory, there are two types of salvage, which includes contract salvage and pure salvage. Unlike contract salvage that operate prior the salvage operation, in which the amount of rewards is fixed and provided within the contract salvage. In pure salvage, the amount of award will be determined after the completion of salvage effort. While it is possible to include salvage contract prior to salvage effort with the approval of master, such contract does not contain the fixed amount the reward. The common salvage contract is little open from salvage contract or known as LOF. The LOF was formulated on no cure no pay principle, and in case the agreement relating to the amount of award cannot be reached, the arbitration will determine the amount. The LOF has undergone many changing or amendment, and the final LOF known as LOF 2000. The characteristic of LOF 2000 is that it contains the obligation of salvor to also pay attention to marine environment issued during the service. This is in accordance with the Salvage Convention 1989, although the application of LOF 2000 should be in written form. It is believed that in emergency situation and written agreement to use LOF 2000 is acceptable. The amount of award then will be decided by arbitration board. Salvage law in Indonesia, Wetboek van Koophandel or Kitab Undang-Undang Hukum Dagang, KUHD. In Indonesia, salvage law can be found within Book 2, Chapter 2, Article 545 until 568K. Such act entered into force in Indonesia since 1st April 1938. The provisions provided within the Act were similar to the Netherlands Act, which was entered into force effectively in Netherlands on 22nd December 1924. When the Brussels Convention entered into force, Indonesia was still under the Netherlands colonialization, and such as the Netherlands ratified the convention, not Indonesia. However, Indonesia also have to adopt the convention through the concordation of the Netherlands Act. As Net 1924 until 573, which was further adopted in Indonesia within as 1933 until 47 GO 38-2. After independence, Article 2 of Aturan Peralihan UUD 1945 envisaged that as long as Indonesia has not made any changes, all Netherlands instruments will still be enforceable. In fact, as 1933 until 47 GO 38-2 has not been changed and still enforceable until the present time. Okay everyone, that's all this article today. Thank you so much for watching this video. Until the next one, bye bye.